Hello and thanks for joining Corporate Governance Platform. The program is proudly brought to you by the Institute of Chartered Secretaries and Administrators of Nigeria, ICSAN, the hub of governance professionals. I'm Dr. Tunde Odeyemi, and in the next couple of minutes, we'll be discussing key issues on the effective board and shareholders meeting. And to lead in the conversation is no other person but a litigation lawyer that practices as a female partner at the Afe Babalola and Co. She is a member of the Chartered Institute of Taxation of Nigeria, a fellow of the Institute of Chartered Secretaries and Administrators of Nigeria, and of course, the current honorary secretary of ICSAN at the Lagos State Chapter, Mrs. Adebusola Sijuade Iyamu. Mrs. Sijuade Iyamu, it's nice having you on Corporate Governance Platform.
Thank you, Dr. Odeyemi.
And we are going to be discussing something that is very pivotal to corporate governance. And these are the issues that relate to board and shareholders meeting.
Okay.
And I would like to kickstart this conversation by asking you, what does corporate meeting entails?
Okay, corporate meetings, what it entails is to give both the shareholders and directors opportunity to meet and discuss issues relating to the object of the company, and that can actually help the company in achieving the purpose of the company. The purpose of the company means the object of the company, purpose why a company was created.
Okay.
So the corporate meeting that you're going to have is like the first meeting. Usually the first one of the corporate meetings are under the comma. You have statutory meetings, you have your AGM, you have what they call this, the AGM and the extraordinary general meeting.
Okay.
That's what there are different kinds of meeting. So, but the very first one is the statutory meeting. The statutory meeting under section 235 provides that when the company is incorporated, section 235 of the Company and Other Matters Act 2020. Comma, yes. So let me just use, in case people that are watching that are not lawyers, so that's okay. I'm pronouncing it in full. So when a company is incorporated, from the date of incorporation, not less than 1 month, but no more than 6 months, a statutory meeting must be held by all the shareholders. And in a company, especially for private companies, you could actually be a director and be a shareholder. Or you can be a shareholder and not be a director. And you can be a director and not be a shareholder. So when we hold that first meeting, after the company has been incorporated, that's okay, now the company is already incorporated, we have our certificate with us. Now, what are the things we need to put in place to achieve the purpose of why we created this meeting, this company? These are one of the meetings they need to hold. Then usually they now hold the annual general meeting. The annual general meetings for the shareholders, where the directors are giving a feedback, because the directors are like errand, let me use the word, a common word that an ordinary man on the road will understand. They're like the errand boys, errand people in the company. They are the ones to direct the affairs of the company, but the shareholders are the owners of the company. So at the AGM, they're giving reports back to the shareholders, and that's under section 237 of the CAMA 2020. They give the reports back, and they both come back at that meeting. Both the directors and the shareholders can be able to effectively analyze what has been done in maybe that period of time, usually 1 year period. What have they achieved? What are the issues? What are the challenges? And they bring their own advice to the directors as well and do all of that. So those are the reasons why a corporate meeting is needed. If there's no meeting, there's no how there can be a synergy between the director and the shareholders, because that means the company will not be able to actually achieve the purpose of why it's actually created. But at the meeting, the issues are put on the table. Both parties bring a possible solution, so that all the things that we can use to drive the company to a point whereby we are achieving the purpose of being created. So those are the things, those are the areas where you can actually be able to do the meeting. Then for the EGM that I mentioned, just for anyone that is listening that can learn from it, EGM is not a meeting that is compulsory.
Okay.
Yes, like statutory is compulsory. That's what they call it, statutory. It's compulsory. Statutory requires you to do it. And AGM, every company must do its own AGM. The EGM is not compulsory, but it is only required where there's an urgent matter that cannot wait for the next AGM. That's under section 239 of CAMA. That must be discussed. So, and must be, it's only, most of the time, such meetings are initiated by directors, by shareholders who own 1/10 of the shares of the company. That's the caption to that one. 1/10 of the shares of the company. Must be a shareholder that owns 1/10 of the voting rights of the shares of the company to be able to initiate that meeting.
That's 10%.
Yes. So before you can actually initiate that kind of a meeting, that, oh, there's an issue on ground. So it's not just a meeting that is called. A company might exist for the next 10 years and might not do anything about EGM. But when there's an issue that cannot wait for the next AGM, they call the EGM, and that's why the law allows you to hold anywhere, because it's because of the emergency at hand. But it's not just anybody that is a shareholder. Maybe you have just 1% share, or you have just some. No, not just anybody.
You must have about 10%.
Yeah, 10%.
Now, before I go further,
Yes.
you actually mentioned that the annual general meeting is statutory.
Yes,
Which
the law
means
requires
compulsory.
it's compulsory. Yes.
And when the organization is formed, there is a meeting that should be held in the first 6 months.
Yes, that is called statutory.
Is that also statutory?
Statutory. That's
So what can we call that meeting?
It's called statutory meeting.
It's just statutory meeting.
Exactly.
Okay.
That is the name of that
Now
meeting.
the one that is held annually is the annual general meeting.
And another name for it is the shareholders meeting, because the meeting where shareholders are given the report back on the activities of the company.
Okay, what are the key issues
Okay.
that are crucial for the effective corporate meetings?
Okay, now for every corporate meeting, the key issues first and foremost is the meeting, business of meeting. For you to, if I'm not aware of a meeting, I won't attend.
Okay.
There must be something called notice of meeting. Then there must be something called a venue. Where are we having this meeting? A place that's it. But the major thing is the notice of meeting, because the notice of meeting is given to those that are entitled to be at the meeting. Yes, where decisions will be taken. Because at that meeting, decisions will be taken, but we call it another word for it, resolutions. So at that meeting, decisions will be taken, and at that time, if we are supposed to be at that meeting and you are not giving a notice of meeting, you could raise an objection against it and go to court. Not giving a member or a shareholder a notice of meeting to a meeting where he's entitled to be is an issue for the court. You can actually challenge that meeting and challenge the decisions made at that meeting, because we are denied opportunity
Of attending
the meeting and even not being heard. And that's one of the decisions they held in Lunga and First Bank.
Case study.
Yes, that's a case study. Lunga was supposed to be removed as a director. They wanted to remove as a director, but was not even given the notice of meeting on where you're going to be removed. And the court said that no, he's entitled to, until he's removed, he's entitled to that meeting. So it shows in the effect of notice of meeting, the very key notice of meeting first and foremost.
As one of the key issues.
Key issues that can actually affect a meeting. Because if I'm not at a meeting where my decision that can affect my interest as a shareholder, I'm not giving that meeting, I'm going to feel left out. And those are one of the things, I think one of the things I'm thinking challenges of KAMA of 2020.
Okay.
That the government, when the House was amending KAMA, they only allow electronic virtual meeting for private company and remove the public company, making it compulsory that public company must still be in attendance physically. And looking at our lessons from COVID, I could be a shareholder and the company, and I'm living in Kano. I can't fly to Lagos for whatever reason might possible. But I'm already denied of attending that meeting because they'll say it has to be held for physically. So even if you are giving notice of meeting, now the law has actually in a way removed some people from the meeting in a public company, not private company. The private company allowed to do virtual whatever. So now they're having challenges with notice. I'm giving notice, but I can't attend. So if I can't attend, the company doesn't have an issue because the duty of the company secretary is to ensure that you have a notice.
Okay.
Like now we will have our AGM, the Lagos State chapter of ICSAN, having an AGM on March 9. I used like 3 days to send notice of meeting in the whole of February. Because every member, and we're sending meetings to over 500 people.
What if the notice arrives after the meeting has been held?
Well, now we'll now go to the issue. There's something we call article of association.
Okay.
It now depends. Let's now relate it. It depends on which kind of company. If it's a private company, there's the article provides. The article runs the internal organization of the company. So maybe it is an agreed way of sending their meeting, of noting their notice. But for the public company, once a notice is posted, it's deemed sent to you.
Once it is posted?
Yes, once it's posted, it's deemed sent to you. Of course, thank God for electronic use now. It's not easy to just send a bulk mail to all your shareholders. But in the days back before, under 2004 KAMA, under 1965 KAMA, no. Once a notice is posted, because that issue led to a lot of cases where people said, I didn't receive your notice of meeting, but they were like, we sent it to the post, but the Nigerian post or whatever post office did not deliver your notice. My duty is to send it to you. Then once it's taken. But if a private company says, oh, when it comes to notice, this is our own arrangement, the law allows private companies to modify their own article in a way that it will suit them, as long as it's not contravening the provisions of CAMA.
Okay, thank you very much.
Thank you, sir.
For the benefit of our viewers and for those that need to be part of this program, we are discussing key issues for effective board and shareholders meeting. I have with me in the studio Mrs. Adebusola Shijuade Iyamu, doing justice to that topic. And you can also be part of today's program by asking questions or making comments on this show. To ask questions, please send text message to 080-2323-1287. 080-2323-1287. Send question or comments via text message only. Please no phone call. And we are discussing issues on the effective board and shareholders meeting. Now, you have mentioned one key issue,
Yes.
which is the issue of a notice must be sent.
Yes.
Are there other issues?
There are
that
other
can be considered?
issues at the meeting that you need to talk about. In the notice states the place, the time of the meeting. Because at least I'm going to attend the meeting, although I'm going.
Of course.
Also the time of the meeting. Then another thing is, at the bottom of the notice, there must be an opportunity for you to write that every shareholder can attend by proxy.
Okay. That is also very key.
Very key, because it's possible the dates chosen by the company have something more important, equally important. For
Okay.
priority, maybe it's better than the medical checkup, and it cannot be able to attend the meeting, and it wants to be part of the meeting. So in that instance, he or she will not be deprived of the opportunity of attending the meeting and attending to his health or her health.
Of course.
So a proxy that he or she nominates, you just communicate within 48 hours of his nomination to the company or to the place where the meetings will hold, that, oh, I won't be attending, but I fill the proxy form, putting the details of the person that will be attending the proxy, so that the person can vote at the meeting
On his behalf.
on his behalf. Because in the notice of meeting there's an agenda,
Okay.
and the agenda already knows the issues that relate that probably going to affect him as a shareholder. So I would have educated my proxy that in this meeting you're me, you're my
Okay.
photocopy. So you're wearing my gown to be there. You're wearing all the rights I have to be at the meeting. So as you are there, you are allowed.
This is what you should vote for.
Exactly.
Okay.
These are the issues. When they raise these issues on the agenda, please let your votes be counted,
Okay.
because it is pertinent to me.
All right.
You get what I'm saying, sir? So those are the things, and that's one of the beautiful thing about meeting. So I don't have to be there, and that's what I'm saying, that if the law had considered, oh, if you want to do this, you can attend online. I don't have to send a proxy.
Okay.
But at least there's an opportunity now that I can send a proxy. So the proxy attends for me and votes on my behalf. So it is deemed that whatever the proxy does at the meeting, you are the one that did it. That decision was taken by you. You cannot later challenge resolutions or decisions taken by a proxy, or what he voted for, he or she voted for on your behalf after the meeting.
When attendance is taken,
Yes.
whose name will be on the attendance?
It is actually the proxy, because you have already notified them.
Okay, that you are sending
You
a
are sending a
proxy.
proxy.
Okay.
So they have your information as a shareholder and the information of the person that is being in attendance on your behalf.
Oh, wonderful.
Yes, they already have the notice. And the other thing, another thing again is quorum.
Okay.
Quorum is so important at meetings. Whether a board meeting, whether shareholders meeting, we must have a quorum. The law provides for quorum. The quorum now has to determine what matters is what is the number of shareholders that determine the quorum. And CAMA is very clear on that. CAMA regulates all of those things. And CAMA stated that, oh, once it's either 25 people can form a quorum, or if the number is not as much as required, then let's say you have shareholders like 6, then 2 is a quorum. What matters is, because you won't do meeting with yourself. So that's the purpose of quorum. I like to bring it down, because some people are watching and they're not lawyers. So quorum is just that, are we okay to move with the meeting? The number of people here, can they take decisions? Can we move on? Can we take things on behalf of those that are not available? That kind of thing. Exactly. So in that instance, quorum is key. So if a meeting, if you call a meeting and there's no quorum, any decision taken there without a quorum is not avoided.
Then the quorum must have been known to everybody.
Yes, the quorum must have been known to everybody. For the private company, the quorum can be agreed in their OAA. That's Article of Association.
Okay.
But for a public company, the quorum must be as provided by CAM.
Okay. Now, you've talked a lot about the shareholders meeting. What are the key differences between the board meeting and the shareholders meeting?
Okay, now the board meeting is only for the board of directors.
Okay.
It's for the board of directors strictly.
Are all these issues also pivotal?
Yes,
to
yes,
the
they're pivotal
meeting?
to it. That's why I mentioned Longa. Longa was the director in First Bank.
Okay.
Yes, it's pivotal to it as well. Anything called meeting, all of these are applicable to them. For the directors meeting, you need a notice. The secretary will issue notice to everybody at the directors meeting. Everyone has its own. That's section 289 of CAMA. So that's when directors hold their meeting. The directors, there must be a quorum. There must be notice of meeting, which the company secretary would issue. There must be what do you call it? But for the directors meeting, it is not expressly stated.
Okay.
For props, because you are actually no directors are any remuneration, so you are the one doing the job.
Okay.
So if you cannot attend the meeting, you can actually notify the board.
Okay.
For your reasons for not attending the meeting.
Now you
Safer that way.
mentioned you mentioned company secretary.
Yes.
How critical is the role of company secretary in corporate meetings?
The role of company secretary is very key. Even the article, principle 21 of our Nigerian Code of Corporate Governance states it there. The role of company secretary. Section 335 of CAMA provides for the role of company secretary. It's so critical in the sense that at meetings, the company secretary is the one that let the board know what decisions they are taking, whether they're in line with the law or not. It's the company secretary that ensures that the minutes of meeting is being taken. It's the company secretary that ensures that everybody that's supposed to be at the meeting has a notice of meeting. It is the company secretary that would work with the chairman on drawing up the agenda. She even does two roles. He or she, don't let me use the word she, because a lot of time company secretaries are women, but we have male company secretary too.
Okay.
Yeah, exactly, we have male company secretary. So he or she has a very cogent role on the board, on any meeting, whether board meeting or the shareholders meeting, because she's seen as the one that has the knowledge of the law to guide the meeting.
Okay.
She's the one that will say, oh, this decision is not totally in line with a particular provision of the law, so we might not be able to go into that. And the company secretary ensures that the codes of corporate governance is followed. Because of people on the directors might not actually be members of ICSAN, they are not lawyers, so at times they are there to talk about business. Not all business ideas are legal ideas, are the correct, good idea or legally binded ideas.
Okay.
Your idea may be a very good thing. It's just like a company saying, oh, there's war in Ukraine. There's a company you can partner with to supply arms. But you can't register a company that supply arms in Nigeria.
Okay.
You cannot. Even though you have said you supply, you manufacture so many things, you can't say because you want to quickly let's modify our object and start supplying arms. It's a way of making business. It's a business way, right? But it's not.
That's not the object of the company.
It's not
the
purpose.
purpose.
It's not
for
the purpose of the
is-
company. And you can't even amend it because it's not something that you are allowed to do like that. There's a procedure for it. So the company secretary say no, this is against the law. So she guides the board. She guides them at meetings. She guides the same board at shareholders meeting when they are giving reports to ensure that. And it tells them that these are the things that are allowed under CAMA. She's like the eye of the law. He or she is the eye of the law at every meeting.
Okay, let me cut you short a little bit. Still talking about the company secretary.
Very well, sir.
We can see that the role of the company secretary is very crucial to the success of every corporate meeting.
Every corporate meeting.
Now, what would you advise? This is a case that has happened.
Okay.
How would you advise or suggest to company secretaries that are watching us now that have a domineering chairman that is always trying to impose his or her views on the members of the meeting, that is the directors of the meeting? So what would be your suggestions to the company secretary to undo or
That
to
kind of chairman.
that kind of chairman?
Okay, thank you very much, Doctor. In that instance, as a company secretary, if I was a company secretary of that kind of company and I've noticed that this is what my chairman does,
Okay.
now you need to assess the chairman in the way that you are being polite and let chairman know that, chairman, in these things, this is what the law says, and you are saying, no, this is what I want to do. So it's obviously that person needs knowledge, needs to be well informed. in that area. So I'll probably recommend a training for that kind of chairman. In those areas where he needs to be informed about things, so that he will understand the reason why I keep checkmating him or her on this, and so that we don't keep having a deadlock at meeting, because I'll let him know that this is your role. That training let him know his role. As a chairman, this is your role. Directors, we have some directors that can be domineering. Director, this is your role. This is my role, so that there won't be conflict of roles and duties at meetings, so that everybody knows that this is my role. I'm not trespassing. But a lot of times, most companies just appoint them. This is our director, this is our chairman, but we're not trained for the work, for our role, to know exactly what we're entitled to, what we're expected to do. So at the end of the day, you give so much work to the company secretary. He's trying to juggle so many things together. When things go wrong, everybody call the company secretary. We're not knowing that if they had actually allowed the company secretary to function as our job, the director is doing his own job. The director knows we have both executive and non-executive director. Non-executive director knows what is his own duty and role too. The chairman knows his role. It makes it work easier. So the first thing I'll first recommend is for everyone to be trained to know exactly their role and how they function in their role within the ambit of the law.
Okay, talking about roles, what are the roles of shareholders association and stock analyst in driving governance in meetings?
Well, the roles, shareholders association and stock analysts really, it's actually, we call it shareholders activism. When shareholders come and show up themselves and say, we too believe in this is what we want to be done, this and that.
They are the owners of the company.
Exactly. They are the owners of the company, so you can't actually stop them. But and on the stock analyst going to say, oh, the shares of the company should be this and that, and directors are saying, no, this is what we've been doing. We are putting this. So the major thing I always see, the few times I've experienced that, is that I just said that as long as what both parties are trying to do is within the governance code, and the company too is seen it that way, and it's going to promote the company, and the shareholders have a good return for their investment, really, there's nothing bad about it. But where we are just listening to, because even if the stock analysts are bringing information that's going to affect what the directors are doing, we are going to come back to having issues. Normally we should work together, but at times the activism of shareholders help the company to put the directors on their feet, so that they're not too relaxed. That's the way I actually say it. They're not too relaxed on what they're expected to do to ensure that the company is making enough profit, to making enough money, to making enough, and at times it places them on their feet let me use this word, I'm trying to be careful, not overspending the money, not unnecessarily creating expense in their own interest, really. Forgetting that the owners of the company are the ones that should make more money. Directors create a lot of expenses that just to a max more. Aside the remuneration, can see I'm losing my voice.
You're actually talking to the public.
I know. But really, that is what happened that's what happened in real life a lot of time. I'm trying to be practical now. So really, but the best thing is for both parties to actually be able to work in one mind and say, okay, this is what the law allows us to do, this is what we can do. Now, the activism of this is for us, we are trying to put you on your feet. Don't be relaxed and just believe that it's business as usual and everything. In those days, now it's even better with such shareholders association. Before, directors would just come to the meeting and just dish out anything on shareholders, and those people just carry their way and go back. But with a lot of activism coming up now, and it puts them on their feet. They know that these people that I want to call an AGM, they know that they are expecting a lot of bombardment, and they themselves ensure that before the bombardment comes from these people, we are actually well prepared, and we have something that they themselves can relate with. Because they're part of the system, they can relate with this. I can't be a member of Nestle, a shareholder in Nestle, and Nestle comes to tell me that you're spending the loss. Okay,
let me talk about this role further.
Yes.
The role can only be played during AGM.
Yes.
After AGM, there is no role for shareholders association.
Well, it's technically.
Okay.
Technically, they don't with AGM. But outside, there's a way they do it. There's a way shareholders can still influence a lot of things. But technically, it's an AGM where you're coming there to actually voice out and do a lot of things.
Okay, I want to go back to company secretary.
Okay.
Accurate keeping and, of course, safekeeping of minutes of the board is recommended by the board for the company secretary to do that.
Yes.
Now, do you think chartered secretaryship profession, as it's been practiced in Nigeria, has trained company secretary sufficiently to be able to carry out this assignment, this task of accurate and safekeeping of the minutes of the board of directors?
Thank you very much, sir. In fact, that's one of the challenges I have with Kama. Let me answer it from that side.
Okay.
Because
and when you are trying to talk about Kama, I'd still like you to talk about, if Kama is to be reviewed in the future, what can we do to it?
Okay, so I should mention
it together.
Okay, so right now, those are the challenges I have with Kama, because Kama allow private companies to pick anybody as a company secretary.
Anybody?
Yes, they allow. It can be a body seller on the road. It's only
Okay.
the company. It's only the public company that they have qualification of we can appoint as company secretary, and shouldn't be so, because what you just mentioned is one of the key books that every company secretary must keep. The minutes of the meeting is so important that it must not only be kept, it must be set safely, because when issue arises, issue can arise at any time. Those are the books you're going to go back to say, oh, I saw some meeting. You were there, because in the minutes of meeting is attendance. Everything taken at the meeting is there.
The resolution.
Resolution taken at the meeting is there. So when somebody raises an issue, somebody that voted in favor of something was an attendance that is coming to raise an issue later on, the meeting will bail out everybody and say, no, you were here. So you cannot imagine someone that is not trained to do the job the way we are trained. He or she might not even see the importance. He might even just write it in such anyhow. But even know that some resolution needs to be taken to CAC for failing, and put the company in problem later. So it's
the resolution must be taken to CAC
yes,
for filing.
If you say
CAC is
Corporate Affairs Commission.
Okay.
Let's give you an example. Now, there was a meeting. We had a meeting, which at the shareholders meeting was agreed that we should increase share capital. Our initial share capital was 1 million, but we are increasing our share capital to 10 million.
Okay.
CAC needs to be, so that resolution, it's only the company secretary that forward it to CAC, then the steps to follow to ensure that that thing is being carried out. But someone that is not well trained is likely not to even do it, and there's time to do some resolutions. We have time within which to file, we have time within which to even notice of meeting, there's time to even issue it. Most meetings are supposed to be 21 days notice, except board meeting that's 14 days. So all of those things, a non-company secretary cannot.
Okay, let me
achieve
ask you
that.
this question before I wrap up because of my time. Does ICSAN have or propose to have a guidance paper on board meetings?
We have
A guidance
a
paper.
guidance paper. If you enter ICSAN office at the secretary, I was thinking that I could still get the secretariat, that I could bring some books along that public can see, that they could actually walk into a secretariat at Alausa Elephant, alternate to the Elephant building, and get books. And I'm advising my public members, public watchers, especially owners of companies, private companies, who have not appointed charge secretary as their company secretary. You have an opportunity to change or let that person be trained by ICSAN
To become a charter secretary?
Yes, it's the same thing, because I won't say just sack the person who has been dedicated in a way, but bring the person over to company to ICSAN. They are trained. There are books the person can read up on,
Okay.
so that it can deliver better and so that the company can be well projected.
Thank you very much for that advice, and that is where we are going to wrap up on today's episode of Corporate Governance Platform. Thank you very much, Mrs. Adebusola Sijuade Iyamu.
FCIS.
Thank you very much, FCIS, and of course, our female partner at Afe Babalola and Company. And for our viewers out there, we'd like to say a very big thank you to you for being part of today's show. We invite you to join us again next week, same time, same station. And on behalf of my producer, Adeboye Galabiro, and technical director, David, I am Dr. Tunde Odeyemi. Bye for now.
Do you have continuity or association plan for your business?
Has anyone shared the concept of sustainability with you?
What about the need to protect the rights of minority shareholders?
What are those ingredients germane to having effective meetings?
For these and many more, tune into Corporate Governance Platform every Thursday on MITV, your darling station, on DSTV 255 and UHF 43 at 4:30 p.m.
Corporate Governance Platform is your best medium for informative and educative strategies for the practice of the corporate governance profession.
Institute of Chartered Secretaries and Administrators of Nigeria, ICSAN, the hub of governance professionals.